could slide back on, Bernard. So there's a lot of talk about the possibility, although probably unlikely after Eric Cantor's defeat, that the Employment Non-Discrimination Act, the fully inclusive Employment Non-Discrimination Act, may come to a vote before the November election. There are those that say the votes are there in the House. It's already passed the Senate. From the front lines, you spend a lot of time in Washington, D.C. Can you give us a lay of the land of the Employment Non-Discrimination Act and give folks a little bit of a brief overview of what that act would do?
Great. So, Employment Non-Discrimination Act, or ENDA, has been pending in various forms in the U.S. Congress for decades. The closest it has come to passage is now. It has passed the full Senate with 64 votes, 10 of whom were Republicans, and it is now pending in the House. In the House, it has just about 200 co-sponsors. It needs 218 votes for a House bill to pass the House. It is super close. The upside of this bill is that it would prohibit workplace discrimination on the grounds of sexual orientation and gender identity all across the country. As Jill identified, a majority of states, a majority of Americans live in states where employment discrimination is not prohibited, either on the grounds of sexual orientation or gender identity. Now, the US EEOC has issued some guidance that says that workplace discrimination on the basis of sex necessarily includes sex and gender stereotyping, and therefore some discrimination on the basis of sex stereotyping and gender identity therefore may be prohibited. But still, the majority of Americans now live in states where it's legal to fire or demote or take adverse employment action based on her or his sexual orientation, gender identity. So this would be a great remedy. The downside of this bill is that it includes broad religious exemptions, exempting from employment non-discrimination a whole range of employers who may use their religious affiliation and actually be allowed to discriminate against LGBT individuals. These broad religious discriminations do not exist, religious exemptions do not exist in any other protected group, protected category. So the challenge for us as advocates is to fight those religious exemptions even as we continue to advance the need for broad ENDA. Speaker Boehner has said on numerous occasions that he has no intention of bringing ENDA to the floor of the House. There are some indications, though, that there may be 17 additional signatories to a discharge petition, which is essentially meant to force the Speaker's hand and say, we are 218 members of the House who are willing to vote on this bill if it were brought up to the vote. So there is some energy behind putting such a petition in place. There's a sense that it would not even get those signatures until after the November elections. But the hope is still there, however small. At the same time, as we heard yesterday, the administration announced that President Obama is considering issuing an executive order. It's being drafted right now, and the goal of the advocates, in fact, we had a call today with our national partners on sort of the thinking behind making sure that the executive order that's issued is not the executive order that parallels the religious exemptions in the ENDA bill right now. So how do we make sure that the very first federal action on employment discrimination is actually the standard that we want to follow, both in the executive branch and legislation that moves through Congress.
Thanks, Bernard. I want to get back to, do you want to say something? Oh, yeah, go ahead.
Yeah, one thing to follow up on that, I was going to bring up the executive order as well, but I believe it was the Southern Baptist Church, someone correct me if I'm mistaken, in this past week voted that on the existence of trans people, and they decided that we don't exist. A little surprising for me, but we're talking about people who have that if they do get those types of wide sweeping religious exemptions, also harkening back to the Hobby Lobby case, if those do go through and if those do become permissible, then we're talking about organizations that would very much use them. A whole church group has decided that trans people don't exist, and furthermore, we mutilate our bodies and defile God's temple, and really corrosive language. So, really important thing to watch. I wholeheartedly agree.
If you don't exist, can I walk through you? That's interesting. I didn't know that. And thank you both for touching on that. I'll get back to you in a second, but I do want to ask Jill to kind of give an overview of the Hobby Lobby case and what it really does mean for, not just the LGBT community, but women and other folks who work in places that may not have, or that may, use religious exemption if that case comes down, in my mind, the wrong way.
Well, the Hobby Lobby case is actually two cases. The Supreme Court took two cases at the same time. Hobby Lobby is a company that provides hobby implements all across the United States, and they have made billions of dollars in the hobby business. They're it's a family-owned company, but they are a corporation. It's an interesting business, actually. They pay their employees higher than minimum wage. So I'm going to say I find them kind of curious altogether. But they fell in love with the Bible. This has not been true always for them. They've been Christian-based, but they have truly fallen in love with the literal words in the Bible. And they have been, when the Affordable Care Act passed, they filed a lawsuit saying that they have religious beliefs that are contrary to what's required by the Affordable Care Act to provide reproductive health care in their insurance policy. Even though the Obama administration found a way to do an exemption, that the insurance companies would have to do that piece, they still felt like they were still going to end up providing care, contrary to their religious beliefs in the reproductive health care area. So the Supreme Court heard arguments in that case, and the arguments were very curious. There's the four judges that we could expect who thought, really, corporations are, you form a corporation so that your private property is protected from the liabilities of the corporation, and you take all those benefits, and how can you have rights? But we found in Citizens United that corporations could donate money to political parties, and corporations could have free speech. So we're concerned that this idea that a corporation could have First Amendment free speech rights, could they also have First Amendment religious belief rights? So that's the Hobby Lobby case. Judge Kennedy's probably going to end up the swing vote again. And I think it is a really bad, a very, very bad view of a large employer. I think it's something like they employ 57,000 people. They're a big employer, and that you would allow a big employer to have religious beliefs that wouldn't provide the basic health care that every woman should have. And then you go from basic health care to not hiring LGBT folks or providing partner benefits. That's all going to be in that package. And if we start going down this slope, this slippery slope that Judge Scalia was so concerned about, but if we go down this way, we're also going to have things like, there's a case that's been filed in Michigan against a Catholic hospital in a small rural community up in the Traverse City area that doesn't have very many hospitals. And a woman went to that hospital with a pregnancy, about 5 months into the pregnancy, and she was in very bad pain, and this was her fourth child, so she kind of knew what pregnancies would look like. This didn't feel right to her, so she went to the hospital, and the doctors there immediately diagnosed, but didn't tell her, that her pregnancy was in her fallopian tube instead of in her uterus, and the child would never survive, and it was left to go, it would have killed her. I mean, that's what happens to those pregnancies. But they're Catholic, the bishops in Michigan have said that they cannot terminate a pregnancy. And so they gave her some pain medication and sent her home. Didn't tell her. So she didn't even have the alternative of going somewhere else. She went home, and a few days later, she was in excruciating pain. She went back to the hospital, and they told her, no, nothing's wrong. You just go ahead, take some more pain medication, and go home. She finally went back to the hospital the third time, and a nurse finally told her what was going on, and she got to a different hospital, and her white blood cell count was in the high infection rate, so her life was being threatened at that point, and that hospital did nothing about it. So the ACLU in Michigan and the National ACLU have filed a lawsuit against the bishops because the bishops did this, not the doctors. Of course, it was the doctors and the nurses in the hospital, but the bishops who control the hospital are the ones who did this. Now, we could really have a really excellent turn with that case, so we'll see how it goes as it's going along. But the Hobby Lobby case is very, very disturbing, that they would even take the case. The appellate court ruled against the Hobby Lobby folks, so it's up at the Supreme Court, and it's a very disturbing change in this country if we start to believe that our founding fathers in this country said that your personal religious beliefs could control your public actions. George Washington didn't even tell people what church he went to because he felt it was such a basic principle of the United States democracy that we separate our church beliefs that we can hold privately and conduct ourselves privately from our public actions. And here we are allowing corporations possibly to have religious beliefs. So
that's interesting. I find it fascinating that lying to that woman in Michigan was okay, but not saving her life. I mean, talk about backward priorities. John, can you talk about, we've talked a lot about Hobby Lobby and religious exemptions, but how does that affect, treatment of people with HIV and AIDS from a policy perspective?
So, this is a very ACLU issue, and I certainly the issue really comes down to the right of conscience, and healthcare providers have a right of conscience to not provide services to someone or provide services that they don't believe in.
let's say we've passed a piece of legislation in Illinois that's being used that way. We don't really believe they have a right of conscience in their public duties, but it's the law.
It's okay. Thank you for that clarification. Where we saw this most prominently was when we worked for probably about 7 years. This was before my time at AIDS Foundation of Chicago, to pass legislation that requires pharmacists to sell syringes over the counter to anyone over 18 without a prescription. And injection drug users obviously need sterile syringes in order to prevent transmission of HIV and hepatitis. So this is obviously an HIV prevention issue. Pharmacists invoked their right of conscience to not sell syringes if they believed that that was going to violate their beliefs because they thought it might be encouraging someone to use drugs. So we could see the same kind of provider invoking that right, for example, to not provide PrEP, pre-exposure prophylaxis, to a gay man when we know that PrEP can very effectively prevent transmission of HIV, or provide medications or even birth control to a woman living with HIV who might want to conceive or not conceive. So these are obviously critical issues for people living with HIV.
It's amazing the intersectionality between all of these topics and how they all relate back to each other in one way or another, because they are very different issues, although they definitely root kind of from the same concepts, right? I want to make sure that the audience has time for questions. How are we on time? Good.
45.
Okay. So I want to make sure that you all have a chance to ask questions. I have lots more, but does anybody have any particular questions right now?
I do remember earlier it was mentioned that many gay marriage bans are being overturned. What's the state of Florida's marriage ban?
Bernard, do you have any information on that? Or maybe Joe?
There's a lawsuit that's been filed. I'll look up specifically how far along in the process it is, because I have that stuff with me. But there has been no decision in Florida yet.
Okay.
But there's a lawsuit filed. I'll look up the process.
Thanks. Yeah.
Is it correct that a company that is self-insured, that buys its own insurance, can discriminate against a legally married couple in a state that honors same-sex marriage, such as Illinois, and use ERISA as the foundation for that? And is there any recourse, and what needs to happen at the federal level to remedy that situation?
Did you guys all hear that question?
I did.
I'll just repeat it quickly in case you didn't. So the issue is whether a company who self-insures can discriminate against or refuse to provide services to someone who is same-sex married under the guise of either the state law in the state that they are operating or under federal law. It's a really complicated federal law called ERISA that I will not get into because I'm not an expert on it. But I'll let either Bernard or John talk on that one.
No, I have no idea. I'm sorry.
Jill.
Okay, so
Try and find out for
I'm
you.
not an employment law lawyer, John. But ERISA does require people who fall under ERISA to not discriminate. So if you are a company that self-insures, you can write those policies. And insurance now, because of the Affordable Care Act, doesn't have as much flexibility in it because it has to provide it has to provide the standard healthcare issues. Where the ERISA law, from the questions that I've got in the past, have been a real problem. It's in retirement benefits and pension benefits, and whether your spouse can get those benefits, and it is whether you are a self-insured pension plan or a retirement plan company. So I didn't really answer your question because in the health insurance area, if that's what you're talking about, I think the Affordable Care Act has affected that, and somebody who knows more about the Affordable Care Act than I should answer, but I don't think there's anybody on the panel, so we've struck out on that.